Those 5 words, "I'm going to kill you," can put you in prison.
I'm gonna kill you. 5 words that can land you in prison for up to 4 years. In California, criminal threats are no joke, and in today's world, where text messages, emails, and social media posts create a permanent record of everything we say, understanding California's law on criminal threats could be the difference between freedom and handcuffs. Let's break down Penal Code Section 422. So, what exactly counts as a criminal threat? Under California law, a person commits this crime when they threaten someone with death or great bodily injury in a way that is specific, unequivocal, immediate, and unconditional enough to cause sustained fear. That threat can be spoken, written, or sent electronically. And here's the part that surprises most people. You don't have to intend to carry out the threat. Just making it under the wrong circumstances can be enough for a conviction. For prosecutors to prove a criminal threats charge, they have to establish all 5 elements. First, that the accused willfully threatened to kill or seriously injure someone. Second, that the threat was communicated verbally, in writing, or electronically. Third, that the person intended the words to be taken as a threat. Fourth, that the threat was clear, immediate, and conveyed a sense of real purpose. And finally, that the threat caused the victim to experience sustained fear. If even one of those elements is missing, then the charge can't stand. Some of these legal concepts are worth looking at more closely. Take sustained fear, for example. It doesn't mean a quick moment of being startled or nervous. The fear has to last beyond just a fleeting second. It has to have some duration and weight to it. Immediate doesn't mean right this second. It means the threat is believable and could realistically be carried out at any time. And unequivocal means the words have to be clear and specific. Something vague like "you'll pay for this" usually doesn't qualify. Now let's talk about penalties. Criminal threats is a wobbler offense in California, which means prosecutors can charge it as either a misdemeanor or a felony. As a misdemeanor, the maximum penalty is up to 1 year in county jail and a $1,000 fine. As a felony, it can mean 2, 3, or 4 years in state prison, plus fines up to $10,000. If a weapon is used when making the threat, that adds another year automatically. And here's something else. If it's charged as a felony, it counts as a strike under California's 3 strikes law. Unless actually reduced, a strike conviction can follow you for the rest of your life and increase penalties for any future cases. Now, what about the First Amendment? Free speech is a huge issue in criminal threats cases. Courts have to balance the right to speak freely with the need to protect people from real threats. Political hyperbole, jokes, song lyrics, and artistic expression are generally protected. But the same words can be protected in one context and criminal in another. For example, words said as part of a comedy routine may be harmless, while the same words screamed at someone's face in anger could be treated as a crime. Context is everything, and courts look at all the surrounding circumstances to decide whether something is a true threat or protected speech. There are also many possible defenses in these cases. A common one is that the alleged threat was too vague to be taken seriously. Another is that the victim's fear wasn't reasonable or wasn't sustained. Sometimes people argue that the words weren't meant as a threat at all, that they were venting, joking, or using sarcasm. In other cases, defense attorneys argue that the statement is protected under the First Amendment. And unfortunately, false accusations do happen. With text messages, emails, and social media posts, words can be taken out of context or misrepresented. But those same records can also be powerful evidence for the defense, showing the true intent behind the words. Let's look at a few real-world examples. A threat like, "I'm coming to your house tonight to shoot you," would almost always qualify as a criminal threat. So would texting someone, "I'll burn your apartment down with everyone in it." On the other hand, something like "I hate you" or "you'll regret this someday" is usually too vague. Posting song lyrics on social media that aren't directed at a specific person also doesn't meet the legal definition. The bottom line is this: criminal threats charges in California are serious. They can come from a single moment of anger, a poorly worded message, or even something said online that wasn't intended as a real threat. But the consequences are very real. Jail time, prison time, fines, a criminal record, and even a strike on your record that can drastically impact your future. If you or someone you care about is facing a criminal threats charge, don't wait. What you do early on can make all the difference. Schedule a consultation today and take the first step toward protecting your rights, your freedom, and your future.
Don't forget to like and share this video, and for more legal insights, keep watching and subscribe to our channel.